Let's give about 5 minutes to allow other people to join us on the call. We'll be starting at 5 minutes past 2. Council with Renew for Uganda, and I would like to welcome you all to today's deep dive session on term sheets and the legal process of private equity. For those of you who've been with us through this series that started in 2020, during the lockdown, where we've had the team from Renew share on private equity, on valuation, and many of you did mention that you were interested in a conversation on term sheets and the legal process. And the team with myself, legal counsel from Ethiopia and Rwanda, are excited to share with you on the same. Before we get started, I would like to go over a few housekeeping rules. Participants are encouraged to stay on mute during the call. You may be on or off camera. And before we get started, please be encouraged to submit any questions that you may have at any time during the presentation. Use the chat window and feel free to ask questions. We'll be able to answer these at the end of the presentation and answer as many as time permits. Please be advised of the following. This presentation is strictly for informational purposes only and does not constitute investment advice or legal advice. The readers of this presentation should consult with their professional advisors to obtain advice with respect to any particular legal or investment matter that is discussed here today. No reader of this presentation should act or refrain from acting on the basis of the information that we will be sharing with you today, and all liability with respect to actions taken or not taken based on the contents of this presentation are hereby expressly disclaimed. Please be informed that this document is based upon information which Renew LLC considers reliable. However, the presentation provided is as is, and no representation is made that the information in this presentation is accurate or complete, nor should it be relied upon as such. Information in this presentation may constitute the most up-to-date legal or other information, but once again, you are advised to consult your legal or investment advisor. For today's session, the areas that we will be covering will be understanding the term sheet and its key terms, understanding the legal due diligence process. We will have a review of the legal documents relevant for a private equity transaction and share with you an understanding, hopefully have an understanding of the deal closing process. I'd like to get our attention for those of us who are on the Telegram to join the Orange Business Network. This is a channel that supports entrepreneurs across Africa. We have over 1,500 entrepreneurs from across Ethiopia, Uganda, and Rwanda. And on this, we do share tidbits with regards to investment, the business climate. You're encouraged to come and interact. Orange Business Network. So for today's topic, before we dive into the term sheet and what the term sheet is and what it represents, the different terms therein, I'd just like to bring your attention to what we call a light due diligence. This is a process that occurs before the drafting of the term sheet and happens after the initial meeting to verify that what was shared by the business at the initial meeting is true or has a likelihood of truth. So for Renew, I will give a personal experience. For Renew, usually for the first interview, either interact with myself as legal counsel or with my colleague Diana, who is a senior investment manager. And during these meetings, over coffee or over lunch, where you have shared with us what your business does, your how you want to grow, the investment that you're looking for. Before we delve into a letter of interest or a term sheet, we will need to do a light due diligence to confirm that what has been said during this coffee meeting or during this lunch meeting holds water or is true. And this information is also used to build the term sheet. But largely, it creates interest for investors in the business proposition. So for this light due diligence after a meeting, some of the documents that we may ask for will be the audited financial statements. And usually for existing companies, we'll ask for your historicals about 3 years. For companies that is startup, where it's a startup or greenfield, that may not be information that you have in your possession, but the financial projections second will be something that you must provide. So these just show us what your scale, what your growth will look like, and help us assess the deal, whether we are interested in an investment. We'll also ask for the business plan for this light due diligence, and this confirms the business. What does the business do? What is the organizational structure? What is a SWOT analysis? And this largely helps to gauge interest internally for your business. Specific to Renew that you may not find with other investors is what we call a deal screening form. For those of you who have gone through the process, you may be familiar with this, but usually after the meetings, after the coffee, after the lunch that we have with the businesses, we will share with you a deal screening form, which is a summary of who the owners are, the founders, why they started the business, what the vision, the mission, the growth plan is for the business. At this point, we will have had a site visit, whether it's to your factory, to your shop, to your area of trade. So this is what is used to discuss internally with the team to gauge the interest that the investor or that Renew has with the business, as to determine whether or not we can move the deal to an active pipeline. And it was at the active pipeline point that we'll have discussions of the term sheet that my colleague Sega will be taking us through. So there'll be a discussion later on the due diligence, but this is a light due diligence, as the word mentions, does not delve deep into the company or the documents, but it's an initial step to gauge whether the investor would be interested in the transaction and what the basis would be for the term sheet. Before we get to a discussion of the term sheet and particular clauses that a business should be keen to understand, we will be launching a poll. The poll helps us gauge for the attendance on the call, the understanding of private equity process or of the term sheets of the legal documents that we have. My colleague Phil Setter will be launching the poll, and I encourage us all to take about 5 minutes to fill this in before we proceed to discussions on the term sheet. Phil Setter. Thank you, Phil Setter. Thank you, Phil Setter, for the poll. Next, we will have my colleague, Segamark Solomon, who is legal counsel for Renew in Ethiopia, who will be taking us through the deep dive on term sheets.
Thank you, Mary. Welcome, everyone, and thank you for joining. So I'll be, as Mary said, I'll be more of covering on the term sheet and like what it means, and more of the major terms that you need to know throughout the term sheet or while negotiating a term sheet. So just to introduce myself, I'm Gamlak Solomon. I'm the legal counsel for Renew in Ethiopia. And yeah, so just to start with what it means and what it refers to, a term sheet is as Mary again mentioned, is more of the third process in terms of like investment closing process. It's next to a light due diligence process. More of the parties come back, sit around, and more of sign a term sheet, which is a document as defined by Investopedia, a non-binding agreement that sets the basic terms and conditions of an investment. It's non-binding because like the clauses there are not enforceable against the company, but there are of course certain elements that makes it binding as well. So we'll dive into those defining characteristics of term sheet and more of like things that make term sheet unique from other types of agreements or the definitive agreements that we will discuss later on in this presentation. So yeah, the first one is like it's non-binding nature. You might hear some investors refer it as letter of intent or memorandum of understanding, but in general, a term sheet is a non-binding agreement, and more of it puts together the basic understandings of the parties involved in there, and except few provisions which as described here in relation with exclusivity, costs and expenses, and also relation with confidentiality and non-disclosure provisions. All the other terms of the term sheet are not binding, which means you are not bound by law to follow those clauses. So why do we need to sign a term sheet? It's more of to put to ground what has been like discussed so far in terms of like elements that we will discuss next in the slide, but more of to put around some of the basic or the major understandings between the parties, and it will be more of a kickstart to the general definitive agreement that your lawyers or you will be working on in the future. So, of course, term sheet is non-binding because like what comes next is the due diligence process, and due diligence process is more of like clarifying what has been discussed is accurate and true. So like if there are findings that affect the understandings in the past, that the terms of the term sheet could change, or even like the relationship could be like terminated if there is a major deviance from what has been discussed earlier. So the term sheet is more of like a kickstart for the next process in the investment closing process, which is the due diligence process. So that's more of the understanding of a term sheet. So you can take that as the beginning of a relationship in the investment closing process. And there are different clauses incorporated in the term sheet. I'll be covering more of like the major terms in the term sheet, which you'll need to understand while engaging with an investor or like discussing through a term sheet. So the first one is like parties, as you might have seen different contracts in the past, or like any contract you will see, like on your desk, starts with defining who the parties are, and for the purpose of term sheets, parties for a term sheet are founding or existing shareholders, the company itself, and the investor. So these are the only parties that should be represented in the term sheet, and no other consultant, or like you might say a broker, or anyone who like alleges himself to be a representative of the company cannot engage in this contract unless it has or he or she has full power of attorney to represent these stakeholders. So, but in terms of like targeted parties to the contract, founding existing shareholders, the company represented by generally the general manager here in Ethiopia, and in some cases, directors representing the company could sign on behalf of the company, but it's more of the combination of these three parties. So the next item that you will find in the term sheet is about investment amount. This is more of defining how much investment the investor is going to put into your company, and more of to proceed with the closing process. And this is mainly dependent on like your first engagement again. Mostly you have engaged an investor, a certain investor, for a certain amount of investment for your specific needs, and that investment based on like different communications with the investor, that might deviate, but it's all about what you have agreed like verbally with the investor initially to more of run your company or grow your company. So this is the investment amount that will be mentioned in the term sheet. And so whatever discussions you have initially, you cannot more of like the term sheet will be more of a reflection of that, and it will not be a new number that you will see here. So yeah, that's more of the investment amount that the investment amount clause specifies. It specifies like how much the investors are willing to invest in the company, and some elements which we will discuss later with about what's the purpose of that investment is. So one major issue that you need to understand here is like why this is more of relevant to you. So like the investment amount, you need to make sure that the investment amount that you need for, or the company needs, is accurate, and more of like it's not greater than what you need, because you don't want to be diluted at the end of the day, or you don't want to be you don't want it to be lower than your investment need, so that like the company will not have that cash to get it like to that growing curve. So it's more of like the investment amount is important for these two major aspects, and you'll need to carefully understand the numbers, and more of like understand whether that aligns with your investment proposal, which you shared previously with the investor. So the other element of a term sheet that you will see is in relation with use of proceeds. So once you see an investment amount, the next item that you will see in line will be like why or for what purpose you are using that money in the company. So the investors are interested in that because one, when you propose, like you presented your investment proposal to an investor, they are more of believing in the investment proposal, and they believe that they are going to get a positive financial return in the future. So they are trusting that proposal, and more of the use of that fund will be based on that proposal and that proposal only. So this again is will be decided by the term sheet, but more of like it is a continuation of the previous discussions that you had with the investor, and it could be more of a specific in a sense that you might approach an investor for specific needs of your company, which could be like hiring a CEO, hiring a consultant for a certain project entering into a specific geographic area or market or anything specific to that degree, or like generic or more of general in a sense that it could be more of like to meet your capex needs or like opex needs and things like that. So it could be a specific or general, and so yeah, so it's you need to be like as specific as possible during your proposal, so that like you meet that you can use that money for what for the purposes that you initially intended for. It should not be used for any purpose that you seem urgent after like you get the investment. It could only be used for like based on your proposed investment need. So that's more of what the use of proceeds in the term sheet specifies. It specifies like why you are for what purpose you are going to use that money, and like what to what degree you are allowed that flexibility in terms of like using that fund. And yeah, so the next item that you'll see in a term sheet is like a general structure of like the investment. It doesn't go deep dive into like specific structures, but more of like it says the general structure of the investment that the investor is going to make. Of course, this is going to be determined by the relationship between the investor and the company or the shareholders. So generally, but in general terms, we classify the investment structure options into three. The first one is equity finance that we call, and the second one is debt investment, and the last one is convertible note or convertible debt. So these are the forms of structure. You might not find all of this in a single term sheet. Some of it could be specifically or only limited to equity financing, and the other could be like a blend of equity and debt, or might also include convertible notes. So it's not a must that a term sheet has all of this, but these are the possible options that the investor might pick. So when it comes to equity, it's more of giving the investor a part ownership in the company. It's more of bringing the investor to your state and making him a shareholder in the company, and more of share in the profits if there is a profit, and share like lose like as you might lose as a shareholder in the company. So that's why we call it like more of a win-win or lose-lose relationship. It's more of like if the company goes down, the investor will go down with that, and if the company gains, the investor will gain more. So this is more of how equity is structured. It's more of you will sell part of your company to the investor for a certain amount of money. And the next alternative is debt financing, which is more of borrowing, as you might borrow from a bank or any financial institution. Private equity investors as well provide debt financing. It could be more of part of an equity financing. It could be in addition to equity financing that the investor made already. But this is more of structured as a debt. As I'm not going to go deep into debt, as you might or you might all of you know about that. It's more of like borrowing money from the investor. And what makes it different? The investor is not part owner of the company. It will, but like whether the company loses or gains, the investor's interest in the company is intact. It will always collect its principal and interest, whatever the situation in the company is. So yeah, so this more of gives the investor a priority in terms of getting returns from the company. But we'll deep dive down between like what makes debt different from equity. So the last option is a convertible debt or convertible note. In some literature, in some documents, you might get it named like that. It's more of like a blend of these two structures. Initially it will be structured as a debt with an option for the investor to convert it to equity at a certain point in time or at a certain window in time, more of based on certain elements being fulfilled. So there are some elements that you need to look through the term sheet which trigger any date, any convertible date, which like the investor might use to convert it to equity. Usually, this is more of when the company gets a second round investment. The existing shareholder who or the existing investor who financed the company in convertible note will have that right usually to convert it to equity. So that's more of usually the usual triggering point, but it could be different triggering points that I might say. So you'll have to look at through the term sheets structurings and understand what you are getting into before signing it. So so as I have said earlier, I will dive into what makes more of debt different from equity. So initially, when it comes to like payments, if you borrow money from the investor, you are more of paying it back in terms of like interest and principal. So whether the company grows to a $1 billion company or like it went down to bankruptcy, the investor is always going to, the debt provider is always going to get its interest and principal. And when it comes to equity, however, like if it's a 20% shareholder in the company, if it turns to a $1 billion company, it will have 200 million worth of shares. If it goes down, it will go down with the company. So it's more of like here, as you can see, the investor's interest depends on the company's performance. And when it comes to debt, however, like there is no such variability. So in terms of control, on the other hand, debt doesn't have any debt provider or like debt structuring doesn't give the investor any leverage in terms of shareholder rights or board rights. But when it comes to equity, it's more of like the investor will get a shareholding right, and it will have that voting rights and will directly involve in the decision-making process of the company. And the requirements, debt usually requires collateral, but usually for investors, it might not be directly collateralized. But for equity, there is no more of collateral requirement, but the investors trust in the company's growth potential. So in terms of value addition, again, debt providers don't have that like value addition in terms of getting to the company, involving in management, involving in strategic decision-making process and everything. But equity, since equity holders have shareholders' rights, they have also more of decision-making power in these regards. So for the amounts that an investor provides, more of its concern, the investor is concerned whether the company is going to pay back that loan with the interest thereon, or like it's more of like, are they trustworthy or not kind of question. But for equity holders, it's more of like, is the company going to grow or not? And yeah, in terms of seniority as a shareholder, as you know, you are the last to get the return from the company. If let's say the company goes into bankruptcy, the shareholders will be the last to get their money. But when it comes to debt providers, they are like paid first, have that seniority when it comes to like repayment. And yeah, in terms of cost, you can consider debt as affordable despite the collateral issue, because like it is more of manageable and that's predictable. The amount of the outcome is more of predictable. But when it comes to equity, the investor is taking more risk here, so it expects more return for that risk. So like more risk, more return is more of an investment test. So yeah, that's mainly the bigger picture of like what differentiates debt to equity. So, and the other term that you could see, you might find out in a term sheet is about valuation. You might look at words like pre-money valuation and post-money valuation. So, like just to give you a brief picture of these two terms, it's pre-money valuation is more of like the company's worth before the investor makes the investment. So, but immediately after the investor makes the investment, the company's worth is considered as a post-money valuation, or so that's more of post-money valuation is the company's worth after the investment is made. So this is mainly what these terms mean, and if you come across these terms, like I believe you will have a picture of that. So, and the other terms that you might find out in a term sheet is option pool. So usually investors will require or like more of agree with the founding members to have an option pool, more of to attract like talents or like employees with talents to help like with the company's growth. And usually it's initiated by the investor, but more of to from the shares of the to be deducted from the shares of the founding members. So that's more of a shares or reserved shares that will be put aside for employees, future employees, or that have like significant that could like contribute significantly to the company's growth. So that's more of what option pool means. Like this is also something that you might find throughout the term sheet. Though not always, so this is not always the case, of course. So, but if you find terms like option pool, you will be interested to know from whose shares these are being reserved, and what percentage is being reserved, and like the details of how they are going to be like allocated to employees. And yeah, so once we understand the basic like terms, it will be good to go through like the different rights that like you might come across in a term sheet. These are, of course, will be in detail discussed in the share purchase agreement and shareholders agreement that you like that are considered as definitive and binding, which you will sign after the due diligence process. But more of these rights will be like briefly described in the term sheet as like rights of shareholders. So these are I'll be focusing on very few of them. The first one is tag along right, which is a minority shareholder protection right. This is more of a right for a shareholder, a minority shareholder, which is like a shareholder having like there are different laws provide different threshold for to define to define minimum minority shareholder, but this is more of like in order to protect those rights, those shareholders. So the first one is so as I have said, tag along right. So it more of gives the minority shareholder the right to tag its shares, or like more of tag its shares to with a majority shareholders transaction, which means like if a majority shareholder, let's say, wants to sell part of its shares in the company to another investor, a minority shareholder who might not be interested to stay in the company with a new coming investor might say, like, I want you to sell my shares with your shares as well. So I don't want to stay in this company if you are leaving. So that's more of what this refers to, and it's more of a minority shareholder's right to tag its shares and sell its shares with majority shareholders transaction. The other one is drag along right, which is more of a majority shareholder protection. This is reverse of the tag along right. So this is more of like a majority shareholder who is trying to sell its shares might find a buyer, but the buyer might not be interested in buying only the shares of the majority shareholder, but might want to acquire the whole company. So in order not to restrict the majority shareholder from this right, the majority shareholder might say like, you will have to sell your shares with my shares because I found a buyer who is going to acquire the company. So this is mainly what drag along right means. And the other term that I'm going to cover here is right of first refusal. So this is more of rights of both, like any shareholder in the company. So any shareholder in the company has that right of like buying shares, have that priority right to buy shares. Either it could be company issued shares or shares transfer from an existing shareholder. Any existing shareholders have that right of getting priority over those shares than a third party who was not a shareholder in the past coming to the company. So this is more of a right of all shareholders in the company. And yeah, again, coming back to terms here again, we have a confidentiality and exclusivity clause. So this is mainly, as I have said earlier, in general, term sheet is not binding, but one of the binding elements of a term sheet is confidentiality and exclusivity. So confidentiality, by confidentiality, we mean like investor might be interested in for like the company to keep the information that the investor is trying to invest in that company be kept like confidential. So the company will have that obligation to, or the shareholders have that obligation to keep that as a secret, as well as investor, the company or the shareholders also might not be interested in for the investor to disclose that they are getting into that transaction. So the investor is also obliged not to disclose this information to third parties about this transaction to third parties. So this is like any violation of this, though it's in the term sheet, is considered as binding, and a violation of this could be like a breach of contract. And the other term, which is also binding, again, though though it's found in a term sheet, is exclusivity. Exclusivity refers to like either investors' engagement with the company as well as the company's engagement with the investor. So regarding that deal or that investment opportunity, the investor wants exclusivity from the company, and the company will only be discussing that deal with that specific investor only. And so you cannot shop around with that deal to different investors once you sign a term sheet. So that's one major thing that you'll need to understand. And for the investor as well, similarly, the investor is more of restricted from shopping between different companies which have like similar business purpose or having in the same sector. So this is more of the exclusivity, and this part as well is binding and is enforceable in front of the court. So the other term, which is also in the term sheet, is a breakup fee. This is more of like a commitment fee, which like the investor or the company will have to engage with that investor for a certain period, which we'll discuss later on as an expiration period. So throughout this period, the parties are required to fully commit to this deal, and if anyone is interested to withdraw from that process without the expiration of the term sheet, they might be eligible to pay a breakup fee. This is more of like for the inconvenience that you will create for the investor, or the other way around, for different investments that the investor make in getting into this deal. So this is in general what the breakup fee means, and you might find it usually in the term sheet as well. So usually you will have, if there is a breakup fee, you will be interested, one, to see the expiration of the proposal, one, and two, also how much rate is set there. It's usually set as a certain percentage of the total investment amount. So you'll have to know before getting into that how much that is. And the other term again found in a term sheet is costs and expenses. This is more of to define who covers what costs and who is eligible to cover a certain cost. So usually this will be defined in a term sheet, and how it's defined is usually the investor will cover the costs that are on his court or on his side, and the company will cover its own costs on the other side. So whatever cost you will incur consulting with a consultant or your lawyer or a finance person, you will have to cover that cost by yourself, whether the deal goes on or it terminates. It's more of an individual cost that you will incur. So the other one, which will tie with the breakup fee, is expiration of proposal. The term sheet will have expiration of proposal clause, which means the investor will have to complete his due diligence process and get back to the table and sign a definitive agreement, which we'll discuss later on, between a certain period. So it's more of it's the expected period that the investor will take to conduct a full due diligence and get back to the company and sign a definitive agreement. So this period is mainly important for one, for the breakup fee, and two, also you'll have to know your commitment in terms of exclusivity and other similar terms as well. And the last one will be more of in relation with governing law and dispute resolution. So though we might not expect for the investors to get into a conflict at this stage of a term sheet, but a dispute is not something that you can avoid. So it might come around, and if there is any dispute, in relation is for the terms in the term sheet, the companies will decide in the term sheet that if there is any dispute in the future, this country's law will be the governing law, and this venue will be the dispute resolution venue. So this is mainly to decide upfront, especially when there are two or more countries involved, laws are involved in the transaction. It's important to decide on which specific law is enforced and which specific venue is the place to go to. Yeah, so that's all for term sheet. I'll get back to Mary again, who will cover the due diligence process. As I've discussed earlier, the term sheet is more of the starting of the relationship. So as soon as you sign the term sheet, the investor will go back and sit with its consultants to go through every detail of your company, every detail of your financial, legal, technical, different aspects of your company, and understand the company, and more of see whether what you have disclosed during your initial meetings before the term sheet, and what have been mentioned in the term sheet is also accurate to on the ground. So I'll call upon Mary to go through the due diligence process with you.
Thank you, Sega, for that. So due diligence. So as mentioned or as discussed earlier, we had the light due diligence. So just as a reminder, the light due diligence will most likely be done with every company that we meet. We have met you, we've had coffee, we've had lunch, we've discussed, but we need to sort of gauge and test the waters and figure out, does what they say hold water? does it make business sense for us to delve deeper, to have a term sheet? So do not be offended when you have a light due diligence done but no term sheet. That will either mean that will happen later, but the light DD is something that is done with all companies that we meet to give us a better idea or understanding. And even if an investment doesn't move forward after the light due diligence, it still means that we can engage and revisit the conversation later and see what progress has been done. So for the full due diligence, so this is largely based on the term sheet, but also key to note is at times these processes don't operate independent of each other and can operate parallel. So you'll find that as you're negotiating the term sheet, we're already beginning that due diligence process, and even drafting of documents is already getting started by the legal team. But for this session, I will be discussing the deep dive, which is the due diligence. Investopedia defines due diligence as an investigation, audit, or review performed to confirm facts or details of a matter under consideration. In the financial world, due diligence requires an examination of financial records before entering into a proposed transaction with another party. So as mentioned, you stated many facts during the business meeting to entice us, to look further into this deal and potentially invest. So due diligence delves deeper to either see whether these facts that were stated are hold water. So you may ask, why conduct due diligence? I mean, we already had coffee. The meeting was scheduled for 1 hour, but the discussion took 5 hours. You may ask, Mary, you're familiar with my product, use my product every week. Why are you asking me the same questions over again? We already had the light due diligence. I shared with you my business plan. Why don't you invest immediately after the term sheet? Why are you wasting my time? But I'm just let you know that the due diligence is defined interestingly by the Corporate Finance Institute as something that the buyer conducts to confirm the accuracy of the seller's claim. And just further to this, the importance of due diligence is that we as lawyers specifically have to identify and mitigate risks with an investment and share those with our investors and with our management before diving into a transaction. Secondly, we do have a fiduciary duty to our investors. As you know, the common statement in business is buyer beware. But we need to be aware of what is happening within your business. We need to understand that what you say does hold water. You don't want a situation where, let's say, you are investing in a factory, but the land on which the factory sits is under lease, and the lease is expiring in 2 years, and the relationship between the landowner and the leasehold owner is not that great, meaning that if we invested, we'd be okay for the first 2 years, but run into challenges in the next 5 years or whatever the span is for the investment. So it is important that we have the due diligence and delve deeper into the nitty-gritties of your business and understand what are the risks. And identifying risks does not mean that there will be no investment, but it only means that we can create ways to protect ourselves as the buyer and mitigate those risks. Another importance of due diligence is that this affects the valuation and the purchase price, as we will discuss in later, but depending on what is revealed or what is brought out from the due diligence investigation to court, this may in fact affect the valuation of the company and the price at which the shares are purchased by the investor. Lastly, the due diligence also helps with structuring the transaction. We might say during the term sheet we had gone in for an equity deal, but during the due diligence process, we realized that they don't own the land, so the business will not be existing in the next 2 years. However, we might find that certain machinery that you have is very key to, say, the cotton production. So we made, instead of having equity and buying into your business, propose to have an asset transfer, sort of purchase the assets, or where we had said, let's have a complete equity transaction with due diligence and the findings therein, we might say, fine, let's have a quasi-debt. Let us first get in with debt before we get our feet wet. Because like as Sega has mentioned, unlike with equity, with debt, payment is regardless of whether the business does well or not. But with equity, if the business does well, that is good news for us, that is perfect. But if the business does not do well, if after 2 years you don't have the land for the factory, we do not make any money. So we may decide that, you know what, let's do debt for The first 2 years, as you sort out your landlord and get that transaction in the clear before then turning into equity. So that is one of the reasons why we would delve into due diligence. So for due diligence, there's different types of due diligence that occurs in an investment transaction, especially for private equity. There's different teams that are part of the due diligence and that we'll discuss later. But for now, we'll start with the legal due diligence that we'll be focusing on for today. Some of the key things that we look out for are governance and compliance. We look at the legal agreements. What are the material agreements? For the example I've been giving about the land, if we look at your lease agreement, when does it expire? Who is the landlord? When it gets to proprietary rights like intellectual property, you may find that companies probably have developed this IP 20 years ago and no one is sure. They assume that they do own it, but due diligence reveals that no, it's a third party that actually owns it, and that has different consequences for transactions. So due diligence sort of focuses in on those key areas: your governance, your compliance. We look at the board. Do you have a board? Do they sit? Are there resolutions? What is the governance structure like in this company? And even with legal agreements, the employee contracts that you do have with regards to key management staff. Is the key management staff the one who's driven the growth of the company? His contract expiring in 6 months. Is he going to up and leave the company, or is he in for a longer term? So those are some of the key things that we look out for in due diligence. We also have the financial due diligence, and that largely looks at things like financial statements, your financial projections. Those may either be supplied by the company in regards to projections or also developed internally by our team, by either the CFO or investment manager or accounts and finance officers. We also have the technical due diligence that focuses on operations, management. How is your sales and marketing? Do you have capacity? You know, when you're enticing, when the discussions were beginning, you mentioned you wanted to scale, you wanted to grow. Technical due diligence comes in to check whether do you have the capacity, do you have the team, are you able to grow to how, you know, how far you said you would do. That sort of pulled us into this discussion. Then lastly, we also have commercial due diligence. And with this, we want to understand the external factors surrounding your business. I want to look at the market analysis. We want to look at your competitors. What is your competitive advantage? The SWOT analysis. We want to understand this business that is operating. Will its environment or ecosystem allow it to expand or to grow? Because all these things, the risks identified in different due diligences or the mitigations are things that will affect the terms or even the transaction going forward. So the relevant parties to complete the due diligence, the most important one is the business. It's the SME, it is you. We will drive the due diligence process, but you do play a very important role. Much of the information does come from within the business. It's information that is private that we do not have access to. So when it comes to your audited reports, when it comes to all the contracts that you have, your discussions, your client list, those are things that you should be ready to provide. We also have the legal, finance, and operations team. At Renew, we have quite a large team and does the work in-house, but also for the SME that is getting into due diligence, you need to ensure that as you come into this process, you have your lawyer, and specifically a lawyer that understands sort of the private equity space or the merger space of project finance and is familiar with these documents. You will need your finance, whether it's your CFO, whether it's a financial advisor, whether it's a consultant. You will need someone to guide you, because the due diligence process, it's quite a deep dive and it be taxing. And you as the entrepreneur, as the owner, still need to run your business. You still need to strategize for your business and focus on that. You don't want to cut off 2 months of your life focus this deal without knowing what the results may be. So it's advisable that you have the team with you, have your legal, your financial operations. They will help you pull that license that you got 5 years ago. You have no idea where it is. They'll help you identify, the legal case you had 15 years ago. The settlements that you had. So you need to have that team ready, because guaranteed that investors have this team ready. So you put yourself at a disadvantage if you don't have that support around you going against or negotiating with an investor who has their team ready. Another relevant party would be the government institutions. So it would be safe for looking at the SMEs and all the internal documents that you do have. There is certain information that is public and that we can obtain. For example, for tax, for Uganda, we can go to the URA to sort of confirm, what is this company doing? Are they even registered for taxes? Let's say if one of your major customers is government, we can check with the Public Procurement Authority and confirm, are they even listed? When it comes to corporate governance, you may have provided documents, but we could also go to the Registration Services Bureau and have the file photocopied, review it, and confirm that is what was provided by the SME similar to what the government records have, and also with licenses. So these are largely the parties that are involved. We have the SMEs, that is very key, that is important. We have the legal, finance, and operations, which the investors will usually be strong on, and SMEs would be encouraged to have the same. And then also the government institutions, or even Google, and just the public domain also plays a role in the due diligence process. So let me just take you through. LDD does stand for the legal due diligence process, but let me take you through the steps or what to expect as you enter into the process. So internally for Renew, we will develop a due diligence checklist, and this sort of divides up, as we mentioned, the different categories. You have the legal, you have the compliance, you have the finance. So each of those and each of the team members will identify what documents we need to confirm in the due diligence. Businesses are different, businesses are unique. So what you would be looking for, say, in a hospital, that checklist would look different from what you'd look for in a coffee trading company, would look different for what you look for in a mining company. So the checklist is developed internally to figure out what do we need to know, what risks are available, are existing in this ecosystem that we need to check up on and inform our investors. So after the checklist is developed internally, it is shared with the company. So we make a requisition for information, i.e. we share the checklist with you, where you and your team. So this is why I mentioned that having a team is very important, because as one individual, if you receive this, let's say 10-page document, can be as small as 3, really depending on the nature of the transaction or the size of investment. But you do not want to be stuck looking at 10 pages of information that you have never seen, because for the past 10 years as an entrepreneur, you have been focused on strategy or more high level. You don't want to get the nitty-gritties. So it's important that as the checklist is shared with you, you're also able to distribute that to the strong team that you have, sort of cater to the different areas of the checklist. So following this, our documents are uploaded to the shared data room. And I think as Renew and as many investors, or even where the world is moving, we're very environmentally conscious. So as opposed to having you photocopy and make copies of these 100 documents that we need, we've sort of moved to having you just scan those, upload them to a shared data room, where all the team, both the team on the investor side and the team on the SME, can delve in and review the documents in that shared data room. So the next step will be obviously the investor, the due diligence team, so that it would be the Renew side, reviews the documents in the data room. There's back and forth with that. Certain documents may be missing or information missing, so it's important to have corresponding team members on both sides. Furthermore, as mentioned, an independent due diligence by the investor team is also conducted from public records. So we do look at the government institutions, we do look at the Google search. We want to see what did you appear on news last week among the companies that the tax authority was shutting down. The regulator for standards, were they at your offices last week? So those are things that we also look at. So whereas we look at the data room, where the SME has provided information, the legal also interested in looking at what is out there in the public domain. So after all this information has been sort of analyzed by the legal team and also other team members, a due diligence report is then developed and shared with, let's say we Renew, that is shared with the management team and with our investors. If it's with the law firm will then share their due diligence report, their findings with their clients. whoever is buying into your company. And largely what this due diligence report does is it identifies the issues, the risks, and the mitigants. So just with identifying the issues and the risks, do not be scared to have risks identified within your business. That is very common. That happens. What is important is that there are solutions to the risks. It may have an impact on your valuation, on the purchase price, but the transaction will still go ahead. Your business could still scale and be profitable for everyone involved in the transaction. So just want to delve a bit into some of the documents for the legal due diligence that we would look into. So these include the Articles of Association and the Memorandum of Association, including all amendments. So what we look out for here is, let's see, the directors. You know, what are the rights of the directors, what are the powers of the directors? The shareholders, what are the powers of the shareholders? Some companies may say a majority or all shareholders must agree, you know, for there's an equity transaction or a debt transaction. We need to know so that we can identify, you know, what waivers need to be made, what consents need to be sought, what amendments need to be made. So it's important for us to sort of review how has your company been structured and how can us coming in as a buyer of shares, as an investor, how will we fit in and how will the process be legal? Then also certified copy of the certificate of registration. Surprisingly, this happens more often than none. Where investors, you will meet briefcase companies that do not exist. So actually this should be the first. We need to confirm that you actually do exist. The government does recognize you as an entity. You are either registered as a company, as a partnership, whatever arrangement it is that you stated. We need to confirm that this is not a briefcase company. It actually is registered. It does exist. It has shareholders. Also important to look at would be registered material shareholder and board resolutions. For example, certain articles or members association may state that for any borrowings, you know, shareholders or the board must approve any debt that comes in. And you find that where that has not been done, where there are no resolutions to that effect, that may lead to dire consequences for that investor going in and making the transaction more cumbersome or more expensive. So it's important for us to deal with it and understand. Fourth, we have the licenses. Simple as business license. We need to ensure if you're operating, say, in Uganda, in Kampala, are you registered? Do you have a license by the Kampala Capital City Authority? Are you authorized to conduct business in that municipality where you're operating? We do not want to invest and 2 years, 1 year, a few months later, we are all over the news. You know, these investors invested in a company that doesn't exist. They're being closed down. They have to negotiate, makes the process cumbersome and unprofitable. So it's very important to understand that the licenses do exist. And also depending on the sector to understand for the licenses, when is the license expiring? What are the terms of the license? Are there any authorizations that are needed before we get into this transaction? Those are some of the key terms that we do look out for with the licenses. So with tax compliant, I think that is self-explanatory with its purposes, because just that may create issues when it comes to fines. We don't want to invest and a year later you realize you invested, say, $5 million, but the company has a bill from the tax authority for 10 years. They have never filed for taxes. They are being fined, and suddenly $5 million is being taken out of your coffers. So those are some of the things that we are keen on looking into. And sort of just to reiterate, with the due diligence, we're looking to identify the risks, but importantly, we expect that they could be there, but they're not grave. Look for ways to mitigate those risks and have the transaction move forward. So just continuing, we have the commercial registration certificate, property or title deeds, material agreements like we mentioned. Just to give an example for material agreements, many times, especially when it comes to trade, when you meet businesses that are dealing in trade, say coffee, or that are exporting, many times they have memorandums of association that are not binding with their buyers. But during the meeting or even the light due diligence, you'll be assured as an investor that, you know, I actually have a contract worth $10 million. The Chinese, the Americans are ready to, you know, to import, or even the Kenyans are ready to import my product. But upon review of the documents, you sort of realize that, nope, it is not binding. There's no price attached to it, so it does not hold water. Although this was key to one of the things key to encouraging the transaction, we find that that is missing. That may be a cause for concern, or maybe even an area for a business sort of realize that, maybe I need to do more negotiation on that. And with litigation, also very important, I just want to understand, have you been sued before? If you've been sued before, why have you been sued before? If all your employees have taken you to court, in the past 5 years, that may be an indicator that this is a red flag, a business not to get into. Or also, if you're suing, why are you always suing your suppliers? Why are you unable to negotiate proper contracts with your suppliers or with your off-takers? So it's important for us just to understand the operations of a business regarding the legalese. How are things working? How are things moving? And just before we dive into the legal documents, just a summary to due diligence. It's very important for you as a business to have a good team surrounding you, to be very organized, because usually the due diligence process, that time that it takes largely depends on how ready the business is for this process. I will want to request for documents that the business has never seen or were last seen 10 years ago, the employees that knew where they are kept, left the business 4 years ago. That all creates a challenge for the business. But also, it's also important for the business to sort of conduct their own preliminary due diligence. You want to make sure that, say, the contracts are signed. There's many instances where businesses will present contracts in due diligence, and upon review, realize that it may be key, it's worth $10 million US, it's to this new market, but the contract is not signed, it's not binding. And that will have an impact on the negotiations. And it can also affect, say, significant holdback by the investors, where we're putting in $2 million US, going to whatever it is that you had stated the investment for operations. You may find that out of that, say, 500,000 is being held back, to negotiate for this intellectual property with a third party, to negotiate, your landlord has increased the rent. So those things, it's important that as a business, before you even delve into the due diligence process with an investor, that you have cleaned house, you've dealt with the third parties, that you've had to deal with, that may have taken a longer time to come to the table, but just it's important to prepare. And it's one of the things about due diligence, it may feel intrusive, it may feel annoying. You may ask, why is Mary annoying? Why is she asking for this over and over again? I thought I told her, I thought we had lunch, I thought she should know better. But it's one of those things. We have a fiduciary duty to our investors, and even as an employee, to renew as a company. So it's important that we do check all the boxes. So do not feel tied down, do not feel offended. Preferably have a strong team behind you that will guide you through the due diligence process, that will be knowledgeable about the different documents that are being requested for, and more importantly, will still give you as an entrepreneur peace of mind to strategize and run your business, as this process lasts between 2 months to 3 to 6 months. You have a team to be able to carry that on. And with that, I would like to move it over to Lincoln, who is our legal counsel for Rwanda. He will be taking us through the legal documents, and similar to the term sheet discussion, he will be sharing with us some of those key clauses that as a business, you should ask your lawyer to take cognizance of. Over to you, Lincoln.
Thank you, Mary. That was such a brilliant presentation, and I'm actually sad I have to follow that. Well, as Mary said, I'm Linguenes Lincoln Ford. I'm the legal counsel for Renew in Rwanda, and I'm just going to get through the legal documentation. I was under the impression that we would first take a break, but this is going to be short, so bear with me. Well, first of all, I would like to talk about a certain joke my cousin told me. Was asking me how, if I'm a boring lawyer, or the cool lawyer, the ones that you see on TV. And I quickly told her that not everything that you see on TV is a direct depiction of what we are doing. But of course, I said I was the cool lawyer. So I'm glad you're all here. I'm glad you chose to join us for this deep dive session. And without further ado, I'll go on with the documentation. I'd like to say that from what Mary had spoken about before, after the relationship is developed between the investor and the company that they're investing in, we move on swiftly to the legal documentation. The legal documentation generally stipulates the relationship between the investor and the company. It outlines their responsibilities, details matters such as the amount of the investment and other terms in the agreements. So the essential documentation I'll be talking about today include the share purchase agreement, the shareholders agreement, the board and shareholder resolutions, and then the documentation that's specific to Renew as a private equity firm. We included the shared growth services agreement, the management agreement, and the director services agreement that Sega will talk more about. So for the share purchase agreement, it's a legal document that details the sale and purchase of shares in a company, while Renew is penetrating the ecosystem of a country. We want to know, as Mary and Sega may have mentioned, we want to take majority ownership of capital and management constrained companies. So an essential bit of the share purchase agreement is the shares, of course. So under that, among the key terms is the purchase and sale of those shares, where contentious questions such as how will the company issue new shares for the investor, or if the existing shareholders will sell their shares. Renew as an investor would want to know which shares will be given to them once they come in to invest in the company, and which shareholders will be giving up their shares, and if the preemption rights have been executed to the fullest. Then also the purchase price per share. This is essential in valuation. It will come down to that during the due diligence, as Mary may have mentioned. So it acts as a yardstick for the company's performance after the reviews and audits. So once the purchase price per share is given, then the investor can move from there. They can know how much the company is worth. They can know how much they'll sell their shares if they need to in the future. And yes, it's an essential term for the share purchase agreement. Also, the percentage of the shares being acquired by the investor. As I told you, Renew seeks to have a majority ownership in capital and management constrained companies, and all the companies that it invests in. So it would be essential for us and significant for us to know how much of a stake we are being given in the different companies. And also, along with that, when the interest in the shares will transfer to the investor, and when the selling shareholder will receive the payment for their shares, there are certain instances where payment is withheld until certain conditions are met, the due diligence is complete. So that is also essential for the share purchase agreement. And moving on, an integral part of the share purchase agreement, as talked about before by Sega is the use of the proceeds. The investor, I would say Renew at this point, needs to know where the money is going. Simply put, you need to know what you're going to use that money for, how it's being used, the profits that are being made off that, expenses, every bit of that, and we make sure that we follow that to the T and report it to the team and various investors. Also, along with that is the closing expenses that we'll speak about at the end. Representations and warranties, closing conditions, and covenants. Yeah. These last three are very essential in all the documentation that we look at for the private equity process, and I will be discussing them on the next slides. Yeah, so for representations and warranties of the companies and shareholders, these are, I would say these are the initial steps that are included in the share purchase agreement. These are just the facts that are laid out to entice us, the investors, to look into our wallets, to pull out funds and make sure that we invest in the companies. So along with that documentation, we review that the company is in good standing. For starters, I'll give you a few pointers. While we're looking through that documentation, we look at if the company is in good standing. That is if it's carrying out its fiduciary duty to its shareholders and the public, and just holding up the ethical codes of being a company in the certain country that it may be registered or operating in. Then also, the company and shareholders are, we have to make sure that the company and shareholders are authorized to enter into equity agreements. Renew being a company primarily involved in private equity, we mostly deal with equity agreements. So we want to know that the company and the shareholders have been in a similar situation before, and there's no restriction of them dealing in equity and shares and all that may be entailed with equity agreements. We also check to make sure the financial statements are accurate. You have to present factual financial statements from audits and all the expense forms and I should say balance sheets. Everything to do with finances has to be presented, and it has to be accurate for us to at least consider this deal. We also have to make sure that there are no legal proceedings against the company or disclosure of that. No investor wants to take on the burden of investing in a company that has pending lawsuits or cases against it, or debts and maybe criminal proceedings against one of their members. No investor wants to do that. So we have to make sure during that due diligence that Mary spoke about, that that is dealt with, and if it's not, then it will be a raw deal for us. Then also we have to make sure that the company is tax compliant, taxation being one of the major drivers of the economy in several countries. We need to make sure that the company is paying its taxes promptly and is declaring them in the same manner, and that generally that they're paying the required taxes. Then also the conditions is a crucial bit of the share purchase agreements. These are bits of the share purchase agreements that can't be compromised on. They're the parts that affirm the representations and warranties. So until specific things are met or have occurred, the investor can't purchase. It would be hard for the investor to purchase shares in the company. Such clauses include that the representations and warranties are true and correct, the ones that I spoke of before. You have to make sure that you're tax compliant and that you don't have lawsuits pending and matters of the like. So you have to make sure those representations and warranties are true and correct. So if we go through the due diligence and find out that, in fact, these are not true or correct, then it constitutes a breach of that condition. Hold on, could you go back just a bit? Sorry, apologies. Yes, and sorry, apologies. Go back a slide or two. Mary? Sorry, just give me a second. Okay, well, we'll come back to that. For essential.
I think Mary dropped off. There might be something with her internet, but please continue.
Yeah. All right, I'll just come back to that briefly. So another essential bit of documentation. Okay, let me just, sorry. Can you guys see my screen?
Yes.
Okay, thank you. So I was saying these are bits of the share purchase agreement that can't be compromised on. These various clauses in the conditions have to be met in order for the investor to purchase shares or be able to look at the company and make a future investment. The performance of all the covenants and conditions in this agreement, the registration of share issuance. Saga will talk about that. It's quite an interesting bit in the Ethiopian corporate law. And then also the completion of due diligence. Of course, the investor can't move on to purchase shares or get involved with the company whose due diligence we haven't yet completed. So all the types of legal due diligence will have to be done before an investment is made. Then also the operational conditions, that's termination or hiring of key staff. Investors would maybe put a condition whereby they would want a specific individual hired or fired from that company in order for them to come in and do investment. So if such and such a person is still around, I'm not investing. An example would be that. Also, you have to make sure the execution and delivery of the transaction documents is made to all parties so that they are just kept in the loop. Also speak about covenants, which are promises that certain activities will be made and that certain thresholds will be met according to Investopedia. I can give an example of non-competition. Most investors include or want to have included in their documentation a clause on non-competition. We want to know that once we invest, that there's a promise, that the agreement will be executed in good nature, I would say, and that members of the company do not go and get involved in business that's similar to what we are offering, or just stealing ideas or intellectual property. And yeah, so once that is included in the share purchase agreement, this would make for a good case for investment. And I was speaking about the shareholders agreement, which is just basically a document that describes how the company is operated and outlines the shareholders' rights and obligations. It's just a piece of documentation that makes sure the shareholders are treated fairly and their rights are protected. So among the key terms in this are the voting rights. We all know it's I would say it's an essential piece of documentation once you're starting a company and once you're pitching to an investor, because they want to know that at least that the shareholding and management is in place, that the operational structure is working for this company, and that they're not just working off words and meetings that haven't been documented. So for the voting rights, we all know that if you want to make sure the company is being run well, not everyone will have the voting rights. You have to allocate shares that give voting rights to specific individuals that will help further the business of the company. So Renew, as an investment firm and private equity firm, would look at those voting rights under the shareholders agreement. Would also look at the board seats and the number of board seats, the decisions that have been made. As I told you, we would like to take majority ownership of these companies. So we'd want to know how many board seats would be reserved for the investor, and how they would impact us and how they would help us move these companies to being market leaders. And then also the share transfer restrictions. I would say maybe if one of the shareholders has failed to pay the amount due for the shares that they contain, we would want to know that and get through with it. Yeah, and then the board and shareholder resolutions, I won't speak too much on that. They're just formal documents identifying the roles of corporate personalities and the decisions of the board. And from now, I'd like to let Saga speak on the company-specific agreements, those last three: the shared growth services agreement, the management agreement, and the director services agreement, briefly, as we go on to the closing process. Thank you.
Okay, thank you, Lincoln. So I won't bother you much about these agreements. I'll be coming back to you with a specific Ethiopian-focused closing process in a few minutes. But just to take you through the different agreements, the shared growth service agreement is more of like unique to our investment needs. It's something that we as an investment firm designed to support our portfolio companies in terms of operation, and that's more of like how that relationship should look like, and kind of if payments arrangements are going to be set there, like how that's going to be arranged will be covered on the shared growth services agreement. And management agreement, this might not be unique to Renew or our investment process only, but usually this refers to the agreement. So like you used to be maybe like you and your family might be the sole runners of the company. At some point in time, you'll take some money, or at some point in time, you'll drop in some money when the company lacks some money. And like it's more of like your personal, you treat your company as your personal property. But once an investor come in, you cannot continue to do that. You have to have a legal structure for that. Whatever you do in the company, either as a manager or like more of as an employee, you like that relationship needs to be defined. So the management agreement is usually setting that agreement with the company. So you are no longer that person who the employees like know as the owner, but it's more of now you are one of the shareholders who is more of managing in this case. So for that service, company and the investors as well agree to pay you a certain amount of compensation, and you will also be held accountable for your service and your commitments to the company as a manager. So that's more of what the management agreement sets forward. And the director service agreement is more of like, so in Ethiopia, it's more of like, we have a board of directors in share companies, but in different countries, as well as in our investments in PLCs as well, though legally not, board of directors is not in that command of like a chain of corporate governance. We will set up a board of directors, or more of a supervisory director, which teams up from founding members as well as investors, and those members will have a role in the company, will have contribution to the company, and for that service, they will have to get a compensation for that. As I have said earlier, this is more of like separating you from the company. You used to be everything for the company. Now the investors, or in our case, Renew comes in, you are not the sole runner. We are in here in this together. So whatever additional suite you contribute to the company, you will have to be compensated for that. And whatever obligations the company sets on you, you will have to be accountable for that. So these agreements are usually mostly set what that relationship should look like. With that, I think we are going to have a 2-minute tea break. Had it been a physical training, this would have been like a lot easier, but I don't want to take you through consecutive like speech. So like let's give you 2 minutes to have some tea break of your own, and we'll get back to you in 2 minutes.
Different jurisdictions, different laws do apply to them, so the processes will be very different, especially Ethiopia different from Uganda and Rwanda. So with that, we'll have Sega kick us off with the closing process for Ethiopia.
Okay, thank you, Mary. So I'll as I've said earlier, I'll be taking you through what like the closing process in Ethiopia specifically looks like. So as soon as the definitive agreements as discussed by Lincoln were negotiated and signed, that means you are legally now in a legally enforceable transaction. So that means the practical elements of that should continue, which means like getting that investment registered, preparing documents, and everything that follows up that process will be covering here. So generally we can cover this in 2 separate categories. One could be for a greenfield investment, which means like in an investment where like there was no company in the past, the investors are just trusting the expertise of the entrepreneur and they are getting into a new venture. So that is one form of investment. And the other one is what we call a brownfield investment, which is like you have been running your company for a while and we came in, we see potential in your company and you yourself as well. So we decide to join you in that venture. So I will not be covering the first one, Greenfield Investment, because Renew also will not be more of one of our investment criteria is having been in the market for the past 2 or more years. So that means we will not be more of engaged in Greenfield investments, but more of brownfield. So my closing process will focus on like what the closing process in a typical brownfield investment looks like. So as soon as all transaction documents are done, this is even advised for some of this to start sooner. What we'll do is having to establish a special vehicle company, which this, I am talking this on behalf of the investor. We'll establish a company in the US for specifically for our case. In the US, that investment vehicle or company will pull the funds and transfer will be that will be more of the shareholder in the Ethiopian company. So we'll establish that company in the US, then have that company certificate of formation. That means like in Ethiopia, that's more of like the memorandum of association of the company. We'll get that authenticated there in the US by the State Department, and also have a resolution by the US company saying that the shareholders of that company, the US company, have decided to join the Ethiopian venture in this engaged in this sector. So we will have these 2 documents, one certificate of formation, which as I have said is equivalent of memorandum of association, and another one is more of a resolution, a board resolution or a shareholders resolution stating that the company has decided to invest in Ethiopia in that specific company. So we'll have those resolutions authenticated by the State Department, notarized there and authenticated by the State Department there. The documents will be shipped by usually, like mostly via DHL to Ethiopia. We will collect those documents, get them authenticated at the US embassy here in Ethiopia, because the documents is from the US. But if it's a British company, that will be British embassy, and like that goes on. So we'll proceed with that, and then the next step will be we'll take that document to the Ministry of Foreign Affairs of Ethiopia, take it authenticated there, then take it to the Documents Authentication and Registration Agency, which is abbreviated as DARA, or like my Ethiopian fellows might know it as Sanadoch. So yeah, that we'll get that authenticated, and like with that, the final stamp being made at DARA, we have all the investor documents prepared and ready, and the foreign company is ready now to join the local company. So now the local company, which is as a business person, your company will have to prepare certain documents. The first one is a resolution admitting the foreign investor as a shareholder in the company. So this could be done either as by issuing new shares of the company, by raising the capital of the company, or by transferring certain portion of the company shares or the shareholder shares from existing shares from shareholders. So these 2 processes have slight difference. And so capital increase, as I have said, is a direct approach. It's more of the company will decide to raise the capital of the company, and the capital of the company will be increased by that investment amount, and the company will proceed to the next stage. Or if it's a resolution, it will be more of, if it's a share transfer, it will be a different approach, which means like the resolution will be a share transfer resolution, and the resolution will have to go to Ministry of Revenues first to get the clearance certificate. So as I have said earlier, these 2 are different, but like once that's done, we will take it to ERCA for clearance if it's a share transfer, and ERCA will clear us that the company doesn't have any tax dues and you are free to transfer the shares. And the other approval that we need to this transaction is approval from Trade Competition and Consumer Protection Authority. So this government body is empowered to follow up or like regulate merger and acquisition activities, and more of assess their impact in the market, so that they don't affect trade competition. So any transaction that exceeds 30 million or like combined capital exceeding 30 million requires this approval from this government body. So if we see that specific transaction or the investment amount plus the existing capital of the company exceeds 30 million combined, we will have to get to Trade Competition Authority and get clearance from them that this will not affect trade, this will not affect the market. And so once we have done that, we'll get approval of admission of this is for foreign investors, of course. So there are different sectors that are foreign investors are allowed to engage, and there are some sectors that foreign investors in Ethiopia are not allowed to engage. So that will be decided by the Ministry of Trade in this area, since it's a brownfield investment. But it's if it's a greenfield, had it been a greenfield, it will be more of the Ethiopian Investment Commission. But now for this case, it will be Ministry of Trade and Industry. So the Ministry of Trade and Industry has to assess whether that sector is allowed for foreign investors. And if that's the case, then we'll proceed with an approval letter from Ministry of Trade. So once we get that, we'll get the resolution admitting the new investor notarized at DARA, as I have said earlier. It's a Document Authentication and Registration Agency, which is more of empowered to authenticate these legally binding documents. And with that, we'll proceed with opening a foreign currency account. Having a foreign currency account in Ethiopia specifically, this is for our fellows not from Ethiopia, it's not a direct forward option. You are only allowed for in limited circumstances to open foreign currency account. One of those is like getting a foreign investment. So in order to get a foreign investment, once you get approval, you will have to open a foreign currency account at any bank of your preference, but you will have to open it. As soon as you get that done, the fund will be transferred from, in our case, in our example, from the US to the foreign currency account of the company, which is recently opened. Then we will take that registration with that transfer and get that capital, which is transferred, registered at by the National Bank of Ethiopia, but through the Ministry of Trade and Industry. This is important because in order to claim any right of repatriation in the future in relation with dividend, as well as repatriation of returns from your investment, or when you exit or sell your shares, any return has to depend on this capital registration letter. Otherwise, you will not be allowed to repatriate any form of return of your investment. So in order to make sure of that, you will have to make sure that your the foreign investors' capital is legally registered. And yeah, so with that, if the total investment is not through share transfer and there is some portion of capital increase in it, that means like this will affect the company's commercial registry in terms of like capital, the total capital of the company, which means we'll have to deposit one, like both in each case, the shareholders resolution has to be deposited in the Ministry of Trade. And in this case, specifically when the capital increases, it will directly affect the commercial registration certificate of the company, which means you will have to get an amended commercial registration certificate from Ministry of Trade and Industry. So this is a general understanding of, or the general process that you have to go through as a foreign investor. So what you need to understand is this process takes time, and usually this is something that we need to collaborate and go through together. But it might sometimes cause a kind of frustration, both from the investor side as well as from the company side, because it results in delay in the investment. But this is something that you'll have to understand. Like if you are an Ethiopian company, you'll have to understand while going through the process. And as an investor as well, you will have to commit some time and more of like work through with your team through the different regulatory approval processes. So that is overall the process of closing the investment in Ethiopia. Maybe we'll have some detailed understanding of this process in the future. But I'll end with that and pass it to Mary, more of to walk you through the Ugandan investment closing process, which might not be as long and as boring as the Ethiopian one, but I hope you will have a good time with her. Mary?
Thank you, Sega, for that. I think just as to give a disclaimer or the pat on the shoulder to Uganda. Uganda is quite very liberalized, and the ecosystem is very encouraging of investors, both foreign investors and local investors. And when investing in Uganda, you'll find that the conditions largely for investment and just closing is quite pretty straightforward than may be in various different jurisdictions. So at closing, documents have been executed, there is wet ink, they have been signed, and you approach legal counsel, say, Marian, what's the next step? How long is it going to take? So for Uganda, largely, at this point, I'm assuming the share transfer forms have been signed by the shareholders, the share purchase agreement, the shareholders agreement have been signed. There's allotment of shares that has been done, and all these different company forms with regards to shares have been filled out. So all this can be registered in one day. And as I think I discussed earlier, when it comes to even the processes of due diligence, drafting the documents of the term sheet, at times they operate parallel, and it's not necessarily that one follows the other. So also similar here to other transaction documents, one may say, should the transfer forms first be fully registered before we can sign the agreements, or what's the step? Usually you can sign all those at the same day, probably just change the dating. Have maybe, let's say, the resolutions dated prior to the date that you have on your execution documents, because the assumption is the resolution gave authorization to enter into that transaction. So it would not make too much sense if on the same date that you had the resolution or your board or shareholders meeting for that transaction, you had this 15 or whatever page document also drafted on the same day, so you can just play around with the dates. So for that, once I receive all the hard copies of the documents, these should be in triplicate, so 3 copies of each. That is a requirement by the Registration Services Bureau, or as many copies as the parties are. One copy, original copy, will be shared with the Registration Services Bureau that they will maintain for their public records. And that also goes back to what I mentioned in due diligence. Anyone is able to go to the Services Bureau and sort of review your file, review what documents you have. So once I have all the executed documents, I shall go to the Uganda Revenue Authority and have assessments done, stamp duty on 1.5% paid on the share transfer forms, and I'll get a barcode for those documents, go to the bank, and then to the Registration Services Bureau and have that paid. A few years ago, you'd maybe take 3 to 4 days for that process to be completed. But as of 2021, that can be done in 1 or 2 days. We have one-stop centers across, especially in Kampala, where in one building on one floor, you will find the URA, which is the Revenue Authority, you'll find the Registration Services Bureau, and you'll most likely find a bank right next door. So if you set aside time in the morning or have your counsel's clerk run around in the morning, all that can be done. There's after registration, let's say 10 a.m. Filed at the URSB after fees have been paid. Yes, you can receive them in the afternoon and distribute them to your parties. So that's how short the closing process is for Uganda. Lincoln, could you share with us for Rwanda?
Yes, thank you. Just as Mary said, for the Ugandan side, Rwanda, in a similar way, is also very liberal and has taken significant steps to encourage investment in the country, and along with that has gazetted a new investment promotion law that is trailblazing, I would say, in the East African region. So after all is said and done, all the documents have been executed and the specific investment has been identified, the company and or the investor will file notarized copies. These notarized copies can be notarized by a designated notary public in the country. Notarized copies of the essential documents, that would be the share purchase agreement, the shareholders agreement, and the different board resolutions with the Registrar General at RDB, detailing the decisions they may have made, if it's to issue new shares to the investor or the share transfer to the investors that are coming in. And these notarized documents will be uploaded to the online portal on the RDB website. Rwanda also has a one-stop center for business registration, intellectual property registration, and it coincides or feeds into the Rwanda Revenue Authority portal also, that makes it easier for us to, or for the investor to register taxes, let's say the capital gains tax on the share transfer. So after that, the registrar reviews those documents and issues a fully updated document on the transaction or the investment that has been entered into by the company and the investor. I would also like to note that in the investment promotion law, it provides for application for investment certificates. An investor can apply, can file an application with in the same process, go to the RDB online portal to register their investment, and within about 2 days, I think, after review from the board, from the investment board, the investment certificate will be issued, and the investor can go on to take part in the specific business that they may want to be involved in. And also, I'd like to note that for the case of priority sectors, in line with the vision of the country, the Vision 2020, in line with that, the law on investment promotion stipulated certain priority sectors, such as IT, health, education, and sectors of the like. For an investor to get involved in that, they would have to submit in the same process, but it would be subject to review by the board and also members of cabinet, depending on what they may have chosen to get involved in. So once that is reviewed by the specific government entities or by the Registrar General, he or she issues the investment certificate. So the closing process in Rwanda, similarly, is also quite short, quite shorter than Ethiopia. So I'll let Mary take over from here. We can have some questions if you have any, and yeah, you can go on from there.
Thank you, Lincoln. So the session was supposed to be 3 hours, but it seems that if you don't have that many questions, we are happy to give you back more time to your day as entrepreneurs to go run your great businesses. And just noting that many of the questions that we have received are from our entrepreneurs in Ethiopia. So with that, I will have Sega take floor, and just he can read from the chat and answer the questions before we close. Sega?
Yeah, perfect. Okay, thank you, Mary. So yeah, all good questions. I will try to address them as much as possible. And if you have additional questions, feel free to add until then. So the first one is, I think, from Samhal, who asked, what differentiates debt investment by foreign investors from that of banks? So mainly this will go down to like how this, what the relationship between these two is. One with the investors is usually debt, more of substantiates an already existing equity investment usually. And two, it's mainly not like different from banks. It's usually not based on collateral, but more of like on like trusting the company, or like trusting the based on the trustworthiness of the entrepreneur. So it's more of like the investor's relationship with the company is more of like closer when as compared with banks. That's the main difference. Other than that, is the modality of provision in terms of legal titles, in terms of priority, in terms of like what comes out of that, which is like a repayment of principal plus interest, is same, though there might be a difference in interest rates. So that's more of like their difference. Other than that, it's more of like a similar thing. And the other question from Araya, who asked, how is debt and convertible note treated in Ethiopia? So Ethiopia has a strict regulation when it comes to financing. So one of the regulated areas is like debt investment. Debt investment by financial institutions is okay, but by private institutions is highly regulated. So let's say, for example, for domestic investors, there is a cap in terms of like how much interest rates they can set. And for foreign investors, it's even like lower interest rates. There is a national bank directive which sets forward like a cap in the amount of interest that a foreign investor might set on its loan. And also, it's not everyone is entitled to get foreign loan. Only foreign investors. And now I think they have expanded to domestic investors as well with a new regulation, but it's mainly with exporters and foreign investors that are allowed, or companies with foreign investors that are allowed to get loan from foreign investment. So like, just to give you the picture, for foreign loans, the interest rate for a term period of foreign loans between a term period of 1 to 3 years, it's a 3% interest rate. They cannot set anything higher. For 3 to 5 years term period loans, it's 4%, and for a term period of 5 years loan, it's 5%. So this makes debt structuring in Ethiopia almost impossible, because no one will be interested to provide a long-term, more than 5 years loan with only 5% interest rate with all those risk factors. So, but other than that, it's allowed, but it's highly regulated and highly restrictive. So practically, you'll not usually find, unless it's more of like an already existing investors trying to support the company, it doesn't make commercial sense for investor or a private equity firm to finance an Ethiopian firm, like provide debt financing. So the other one is in relation with foreign currency accounts that so the question reads, is there a threshold amount to open foreign currency account? So so as I have said earlier, not everyone is entitled to have a foreign currency account, but when it comes to foreign currency account as well, there are different types of foreign currency account. So for example, exporters have foreign currency retention account, which is like whatever retains they get from their export earnings, they can use, they can deposit certain part of that as Forex. And when it comes to investment, however, it's more of the total money will be in foreign currency account. So these two are different, but in general, it's a company which got a foreign investment has to open a foreign currency account to get that investment, and that money will be deposited as foreign currency in the bank, in that bank account, until the company decides to convert it to local birr or like import something that is important for the company. So that's more of the foreign currency account, and the threshold is not in terms of threshold, but in Ethiopia there is a minimum threshold for foreign investors. So minimum capital requirement for foreign investors investing in an already existing Ethiopian owned company is 150,000 USD. So that threshold has to be met for per investment project for a certain investor to be admitted initially to a company. So you can set that as a threshold if that makes sense, but more of not in terms of for the bank account, but more of for the foreign investor. There is a minimum capital requirement that needs to be met. And the other question again relates with foreign currency account. It is can foreign currency account be opened at head office or at branch? Also, this is mainly left for the bank, but almost all banks only allow opening of foreign currency account at their head office. But I know commercial bank, for example, there are some limited branches which they, in addition to the head office, that are allowed to open foreign currency account. But most of the private, I think all I can say all are more of process opening of foreign currency account at their head office. But commercial bank, which is the state giant, I know that they have additional branches which you are allowed to open foreign currency account at. So I think that's for me for questions in relation with Ethiopian based investment process.
Thank you, Sega. So for Peter, I will be recapping the closing process for Uganda. So let's say for starters, the memorandum and articles of association have been amended or even did not need amending, but they did provide for the share transfer or for the transaction. Resolutions have been drafted authorizing the transaction to go ahead. The share purchase agreement has been drafted. The shareholder agreement has been drafted. Transfer forms have been filled in by the shareholders who are transferring shares. The company has drafted the return of allotment. And all the documents needed have been transferred. The next step is to ensure registration at the Uganda Registration Services Bureau. So the first step, the first point will be going to the to the URA, which is our tax authority. A stamp duty of 1.5% is paid for the value of the share transfer. So an assessment needs to be done. An assessment is done for stamp duty and also for the registration fees. Following the URA desk where all that has been done, you will then go to the bank and make payments for both the stamp duty and the registration fees. Once all that has been done, back to URA to confirm that stamp duty has been paid. and barcode is given. And from then we'll go to the Uganda Registration Services Bureau and hand in the documents to the registrar, who will review the documents just to ensure that all the signatures are in line, the documents are in line, are in compliant with the Companies Act, or also with the memorandum and articles of association of the company, that those who have signed all the documents are who they say they are, confirming directors' signatures and shareholders and so forth. So this process, as I mentioned, depending a few years ago, could have taken longer, but once documents have been submitted to the URSB for review, it is a faster process these days, so it can take up to 1 to 2 to 3 days, really maximum. So from there, they will return to you, say you have filed 3 copies, they'll return to you 2 copies of the document, and they will be registered. There will be stamps on each of those documents signed by the registrar, and it's from there that you can then do the registration, then distribute the documents as is. And that is the process for Uganda. Quite straightforward or easier. Then we saw there was a next question about the PowerPoint. Yes, the presentation will be shared with all the participants for the training. We will share both the PowerPoint slides and the audio recording and the recording for this presentation. With that, if we have no more questions to ask, I would like to thank you all.
Yeah, I think a couple of questions to address again. May I have that made?
Over to you, Sega.
Yeah, sure. Okay. So there are a couple of additional questions. One is in relation with like getting any, if there is any chance of getting funding Greenfield Investment in Ethiopia, if yes, how? So there are different investment firms or private equity firms focused on different stages of a company. So for Greenfield investment, you'll have to find like investment firms or PEs that are focused on like startups, or like depending on your current state. If you have like a track record of other businesses, you might have that strategic relationship with an investor to more of adapt to that business in a separate venture, which still will be treated as a greenfield, but more of adding to your current existing investment. But there are, though not a lot, there are some good opportunities there, which you need to navigate through. With that, I would also like to promote one of our platforms, which is a Chigintopia show, which is a television show in Ethiopia, which is focused on financing small startups in general, existing or more of ideal stage. So you might register for that and maybe pitch for our investors for potential investment. So that's that. And one other question with Daniel is regarding foreign investment and the minimum capital requirement. So his question was the law stating the minimum amount of investment allowed, i.e. 150,000 USD for joint venture and 200,000 for foreign company investing alone. Does this law still apply? So like there used to be the investment law. Ethiopia adopted a new investment law in 2020, April 2020, which repeals the 2012 investment law. It changed a number of things, but specifically this, when it comes to the minimum amount of investment, there hasn't been any change. So it still continues and still applies, and foreign investors investing with domestic investors are still required to meet the minimum capital requirement of USD 150,000. And yeah, of course, as you have said, if they are investing alone, it needs to be 200,000. There are also certain exceptions to that rule, more of in terms of profit reinvesting in some sectors in relation with technical consulting and architectural, which reduces minimum capital to 100,000 and 50,000. But in general, that law, that provision hasn't changed. So a number of other things changed. Yeah, over to you, Mary.
Do we have any more questions?
Okay, additional questions. So, there is an additional question from Pelo Bella. You stated in the beginning of the meeting that this meeting is focused on brown venture, not green. However, I wanted to make myself familiar with the regulation for new upcoming business in green venture. So, like, let me just give a brief overview of how the new Greenfield Investment for foreign investors goes, or like with foreign domestic investors working in joint venture with foreign investors. So the concerned government body will not be Ministry of Trade, but it will be the Ethiopian Investment Commission, and it will encompass two processes. One is like the coming together of the shareholders, and the other is also like, since the company was not established, it's also the establishment of the company. So the Investment Commission has that one-stop shop service where they provide all the registration and every like different tax identification issuance and every other services that are related with company incorporation at one window. So you can use that at the Ethiopian Investment Commission and go through, fill out an application form, establish memorandum and articles for the company establishment, and proceed with that. When it comes to capital registration and everything, the same process goes to like the brown venture, but more of like you'll start your process at the Ethiopian Investment Commission, and you'll start from there. Yeah, I think that's all, right?
Yes, that looks like that is all. If anyone has any more questions, please feel free to reach out to either myself, Sega, or Lincoln. Respond to the Renew email from which you got the invitation to attend this training, or after you receive the feedback forms, feel free to send the questions to us. So we are ending early. We'll give you a little over 30 minutes of your day back, but thank you for joining us for this deep dive session, and we hope to interact with you. For the businesses that are looking to raise capital, please feel free to reach out to either myself, Sega, or Lincoln. If you're in Rwanda, Ethiopia, or Uganda, we would love to get to know your business and hopefully get through a term sheet and due diligence. Thank you all, and have a good evening.
Okay, thank you.